The title is FinCEN finalizes new residential real estate reporting rule, and it's effective March 1st, 2026. Beginning March 1st of 2026, a new residential real estate rule from the Financial Crimes Enforcement Network, which is FinCEN, will require federal reporting of certain residential real estate transactions. And now the key word here is certain. Okay, we need to hone in a little bit there. There are certain criteria that this would fall under. This does not mean all residential. It says the rule expands anti-money laundering oversight to the residential real estate market and is intended to increase transparency into acquisitions of entity-owned property. Says transactions involving mortgage financing from regulated financial institutions are generally excluded, as are transfers directly to individuals. Okay, so like me to another person. And if the loan is being handled by a financial institute, a regulated financial institution like a bank or a mortgage lender, if it's being handled by that, this is not required. If it's individual to individual, it's not required. The rule applies to non-financed, typically all cash transfers of U.S. residential real property where the purchaser is a legal entity or trust. Okay, so if you have an S Corp, an LLC, or something that owns that property, or if it's in a trust or wanting to be put into a trust, it would fall under needing to have these requirements met. So that's the criteria here. So what do we have? We know that it's not every single residential property. We know that it is only those that are being under an entity owned. In other words, going to LLC or a trust. If it involves a regulated financial institution, it's not required. That is excluded. And if myself sell to somebody else, it's a cash deal, it's excluded. For the most part, it's non-finance transactions. Residential, all cash. There is the umbrella of what is required. All right, it says covered properties include 1 to 4 family homes, so single to 4 units, condominiums, cooperatives, and certain unimproved land intended for residential use. Unlike the Corporate Transparency Act, which places reporting obligations on entities themselves, the real estate rule assigns reporting responsibility to professionals involved in what? The closing process. Okay, so this is where it's like a lot of my agents are like, what do we have to do? The reporting responsibility to professionals involved in the closing process. And it goes on to say settlement agent, title agent, escrow agent, or attorney handling the transaction. Okay, the requirement, the process is handled by them. It's not your job to do it. Only one report is required per transfer, and parties may allocate responsibility by written agreement. The report is filed electronically with FinCEN after the closing, and must include information about the property, the seller, the purchaser, and beneficial ownership information for the purchasing entity or trust. Really what we're getting down to here, and when I wrap up this article, I'll give you the things that are on that FinCEN report and tell you kind of this is what they're looking for. That's where I think the real estate agent can help speed processes along by being upfront and communicating this to their clients. But what's happening here is there's a lot of laundering going on where buyers can come in with shell corporations and buy property. A lot of times just money laundering, moving money around. So what's happening is this government agency is wanting to crack down to protect consumers from this type of laundering. So the people that we're dealing with on the other side of the deal are real people that are wanting to buy the property for residential use, not to launder money through. So it's cracking down. And this is crazy that this is even a thing, but this is happening a lot, to the point where this has now become a must. Trust-related transfers warrant particular attention under the rule. Transfers of residential real property to revocable trusts and irrevocable trusts may be reportable if the transfer is non-financed and no exemption applies. In these cases, FinCEN requires reporting identifying information for the trust, as well as information about individuals who exercise control over or have significant beneficial interest in the trust. As a result, Clients using trusts or for estate planning, asset management, or privacy purposes should expect additional information requests and potential timing considerations at closing. There's a lot of pushback a little bit on this because there are a lot of people that want to stay autonomous. They don't want people to know anonymous. I'm sorry. They want to be anonymous to the transaction. They don't want people to know who they are when they're buying a property. This kind of causes a little bit of tension there. We'll see how this plays out. If there's any room for that still to be the case, we don't know exactly how that will look. But the reality is, I have a feeling it's going to be really, really hard for buyers to stay anonymous. There are so much fraud and so much laundering going on that it's almost crucial that the person buying has to be disclosed. I think that's where it's leading. So there's going to be point of tension there. I do think so. And when you start talking about celebrities or people that are big investors that don't want people to know that they own certain land or their entities buy it for good reasons, right? There's the logical reason why they do that. I think there's going to be a problem here. I think it's going to be really hard for them to continue to do so. All right. It says the rule contains limited exemptions, including transfers occurring by reason of death, divorce, court order, bankruptcy proceedings, and certain Section 1031 exchange transactions. These exemptions are narrowly defined and must be evaluated carefully. So there's some scrutiny there that can still take place, right? All right. It says, although the rule does not take effect until March 1st, 2026, buyers using entities or trusts and the professionals advising them. Look, here's the thing. I understand it's not our obligation to make sure that they do what they need to do. That is on the attorney, closing agents, title companies, all of them, right? But I am of the mind that a true professional is going to help their client through the whole process, and they're going to communicate everything along the way. So there's no unforeseen circumstances that pop up. So as agents, I would put us into the category of the professionals advising them. Not that we're responsible, but I think there's an important factor on why we should let them and help them be aware. We owe it to them so that when they go to closing, they know that even though they own this entity, there is certain information that they're going to be required to disclose. It's going to make the transaction a whole lot smoother, guys. The new requirements will affect transaction timelines, closing documentation, information gathering practices, particularly in all cash and privately financed transactions. There you go. That summarizes it all up, right? So there you go. It's going to affect not legal entities, LLCs, trusts, and those type of things. They now face a stricter way of transparency requirements. The goal right here is basically to identify the beneficial owner of the transaction. In other words, the human behind the entity. Okay, that's the aim of this. So if I was to summarize why we have this, that's why, right? Who is the actual human being behind the entity that is buying this property with all cash? Are they just moving money, or is there a real person? So there is specific criteria that they need. All right. Let me just tell you some of the information. So if you guys wanted to figure out a way when you're meeting with clients that are all cash buyers that are buying through a company or a trust, here's some of the things that they will need from the individual. Okay. They're going to need their full legal name. And that's the individual, the owner of that company, or the beneficiary of the trust, or the executor of that trust. They need the date of birth of that individual. They need the current residential street address of that person. They also need identification documents, a non-expired document, such as, driver's license, state, local, issued ID, passport, whatever it may be. They need like an ID number, jurisdiction number, unique number from a document in regards to what state and jurisdiction they live in, what identifies that entity, typically like EIN number or your local state filing number, those type of things. They will need document image. They need a scan or documents of the ID and all that active in there. Then they would take all that information and they would submit that through an agreement with FinCEN ID.